and welcome to Terms and Conditions, a podcast by Conn Maciel Carey. I am your host, Letitia Silas. I am a traditional labor and employment attorney and partner at Conn Maciel Carey. I lead the firm's traditional labor practice. Here on Terms and Conditions, we discuss workplace issues and the law in a grounded and accessible fashion to help your organization be an employer of choice. Our goal is to keep you informed about workplace law, your rights, and your responsibilities. We aim to help you stay ready so you don't have to get ready. Today, we are going to discuss restrictive covenants and non-compete agreements and what they mean for your business and your employees. By the end of this episode, you will be better informed about your rights and responsibilities when seeking to protect your valuable business interests with the use of these tools. For this discussion, I am joined by my esteemed colleagues, Jordan Schwartz and Darius Rohani Shukla. Welcome, gentlemen. Why don't you introduce yourselves, starting first with Jordan?
Thank you very much, Letitia. It's great to be on this podcast. I've been practicing law for over 20 years now, and this is my first podcast, so I'm very excited. Like you, I do labor and employment law. Been doing that my entire career. I also kind of have a niche where I do Title III of the ADA, which is public access and helping hotels and restaurants and stores make sure that they have proper facilities that are compliant with the ADA. But for the most part, I still do employment law, which includes, among other things, advising my clients, employers on complying with, on drafting and then complying with the non-compete agreements that they draft, and litigating. The cool thing about restrictive covenants is you litigate on both sides. Even though you're on behalf of the employer, you might be litigating to enforce the non-compete, or you might be litigating on behalf of a new employee to get rid of the non-compete. So I really enjoy this topic. Of course, I also represent clients in all the other traditional employment law topics like harassment, discrimination, wage and hour disputes, and every type of employment and labor issue that there is.
And how about you, Darius?
Hey, Letitia, thanks for having us on. Really excited to chat today. So a bit like Jordan, I spend a lot of my time working on employment issues that can range from litigation to counseling. The purpose of the podcast today, some of my favorite stuff to work on is restrictive covenants, be it non-competes, non-solicitations, and then some of the trade secret issues that arise around them. So excited to kind of chat about that more in depth today.
Awesome. So now, what is a restrictive covenant? Why don't we start there first?
Sure, and I'll start off if you don't mind, Darius. I remember when I was beginning practice, like, what is this restrictive covenant? I didn't really realize it really is what the name implies. It's, covenant is a promise and a restriction is a restriction. So you're promising to be restricted from doing something. And a non-compete is, people use it interchangeably. It's not necessarily interchangeable. A non-compete is one form of restrictive covenant. That's something that, you're restricted from competing. A non-solicitation agreement is another form of a restrictive covenant. Even a non-disclosure agreement, it's anything that an employer, a company is restricting its employees from doing, either while they're employed or more likely, and that's kind of a given, while they're employed. It's more likely where the litigation occurs is if you're restricting a former employee, or you're restricting someone from doing something after they're employed.
Okay, so Darius, why should employers care about these tools?
So they're important to employers for a number of reasons, but the threshold reason is that it allows them to keep their workforce pretty stable. It allows them to protect their information, their secret sauce. So the idea, if you have a non-compete, is that if you've spent a lot of time, you hire an employee, you spend a lot of time getting them up to speed to work at your company, You teach them, they'll provide services to you. And the concern for an employer is that the employee will learn all these skills and then, up and leave and go to a competitor. And if they go to the competitor, that could put the initial employer's, business out of business. The concern for an employee is that if they are signing a non-compete, that means that their options moving forward might be restrained. It means that it's difficult for them to move to a different company, maybe not a competitor, maybe someone else, maybe that's in the same realm that they're concerned might be a better fit for them. So it's pretty easy to see how there's a push and pull here. And that's why the agreements themselves are so important. For an employer needs to be really careful that when they, get an employee to sign a restrictive covenant, that it's really carefully defined to really protect what they need to protect. If it's overly broad, and we'll talk about later what that really means, then it's not going to be enforceable and it's useless to the employer. And then from the employee side, just as important is that they look at the restrictive covenants before they sign, because if it's something that's going to be affecting their career goals, if they intend to move on somewhere else down the line and they're signing a restrictive covenant that means they can't do so, they're going to be a world of hurt when, X amount of time they decide to leave, but the agreement makes it really, really difficult for them to do so.
Well,
Letitia, if you don't mind, one thing to add to that, I just think why they matter. If you're an employer and you don't have them and you're thinking about, should we go through the trouble? Is it worth having some sort of restrictive covenant? At the end of the day, if you have something in your business worth protecting, a restrictive covenant helps protect that thing, whatever it is. If it's a actual sauce, if it's a recipe, if it's a formula, if it's just employees, it doesn't have to be something tangible. It could be something intangible, secrets. Having some sort of restrictive covenant, regardless of the type, helps protect something that you as a company have spent time, money, and resources building. And like Darius said, for someone potentially to take what they've learned and then to a competitor, and that competitor doesn't have to spend those time, resources, and money, and they just have that information, that's why they matter. You want to protect yourself.
Absolutely. And so what I hear both of you saying is that really restrictive covenants are important for all parties of the relationship to know about. They both have to know. Everybody involved needs to know what their limitations are, what the scope is of their role and their responsibilities with respect to the employment arrangement, and even after that arrangement has ended. So we're going to talk about a variety of restrictive covenants, but we're really going to focus primarily on non-compete agreements. So why don't you kick us off by sharing with us what a non-compete agreement is?
So we started talking about restrictive covenants, and non-competes are a type of restrictive covenant. What they are is a contract between an employer and employee, sometimes found in an employment agreement, that's going to restrict what the employee can do after they leave their employer. And what it means in terms of like the word itself, it means they can't usually compete with their present employer by working for a competitor. That's going to be, defined slightly differently depending on the agreement, but at a threshold level, it's an agreement that prevents the employee from competing with their initial employer in the future.
And does that also include setting up their own business enterprise that might compete with the employer?
In general, yes, it's going to do that. I mean, there's specific rules and specific laws and case law around what, preparing to compete actually looks like. But in general, the idea isn't so much like sometimes you'll have a non-compete that will refer to a specific competitor, but the idea is that competing with the initial employer. So were they to go start their own company, they would still be competing with their initial employer. So yes.
Yeah, just to jump in here, that's why you never want to use a boilerplate, non-compete agreement that you find online. You want to have an attorney who's drafting a non-compete agreement on behalf of your company, because that's such a good question, Letitia. And it really depends on your company and what you're trying to protect. Sometimes the kind of generic language is you cannot compete on behalf of a competitor or on behalf of yourself for the next year or so, let's say. But sometimes you actually want to draft depending on your industry, if you're worried about like your three main competitors, there's four big guys in the industry, and you're one of them. You want to say you can't compete, you can't go work for the other three, 1, 2, or 3. Other than that, you're fine. And then if someone wants to start their own business, more power to them. So it just really depends on the industry and what you're trying to compete. But in general, it's just the typical, you are saying, yes, you also can't go open up your own shop, but that's certainly not universal.
Right. Okay. So what are some of the restrictions that could be imposed under a non-compete beyond the I promise I won't go work for somebody else who competes with you, or I promise not to set up my own business that competes with you?
Okay, so in terms of like, what are the restrictions? I mean, the idea is, 1, role specific, but 2, the main pieces are going to be, the geography and the time. And that can depend on the role. The threshold thing is that it really is going to depend on what the employee is doing. But a lot of times what you'll find litigation around is the time, like how long before they can compete. Usually you're not going to find any restrictive covenant that says you can't compete forever, but usually there'll be a significant period of time. And the geography will depend. I mean, it's changed a lot. Once upon a time, I think geography would have been a really central factor in non-competes. But now, depending on your role with remote work, if you have a restrictive covenant that makes it difficult for you to compete within the East Coast, and now that's probably not going to be a very helpful term in restrictive covenant, because you can probably take the same role and work remotely on the West Coast for some types of roles. So those are the other terms you might find in a restrictive covenant. There's I think kind of relevant to the discussion is this idea of the janitor rule. The janitor rule is a rule that's found in a lot of non-competes, and it's this idea that when you have a non-compete, oftentimes we'll talk about what role the employee can take in the future, but there's this idea that you can't have a non-compete in most jurisdictions that says you can't go work for this company in any role at all, i.e., let's say you're a basketball player and you have a non-compete. That non-compete can't say you can't go to another basketball team and work as a janitor. The idea, you're not taking any specific knowledge, any specific skills that were honed at basketball team 1 if you go work as a janitor at basketball team number 2.
Yeah, that's a good point, Darius. The other thing employers want to keep in mind when drafting a non-compete, though, is there's always like a push and a pull. You want it as narrow as possible so it can be enforced. But if it's super narrow, in terms of, I mentioned earlier, let's say you're only limiting it to 3 other companies, then it's possible you might actually be able to have it broader and say you can't work for those 3 companies because they are our only 3 competitors and we really don't want you. What Darius said is right about the janitor rule, but if you limit it to 3 competitors, you may even be able to say you can't work in any capacity. Whereas if you're just saying you can't go work to any competitor, however that's defined, we're not going to define it in the entire United States or in the entire world, then you certainly want to say in the exact same capacity that you worked here as a VP of sales or something of that nature. So it's always a little bit of a push and pull about what is more broad. If one part of your non-compete is more broad, you want another part to be more specific, and vice versa.
So what I hear you saying is that the non-compete has to be narrowly tailored with respect to the restricted activity, where the restriction will apply in terms of geography, and for how long the restriction will be in place in terms of the duration. Is that accurate?
That is accurate, but there's one more key component. Everything you said is accurate, but it has to be narrowly tailored. And then the next phrase is to protect a legitimate business interest.
Ooh. Okay, explain that to us.
Yeah, that's the tricky part. But every single non-compete, you want to think about what legitimate business interest are we protecting? We have, and the easiest one is we have trade secrets. If I go across the street to the exact same shop and bring company A's trade secrets to company 2, I am not protecting the company, or the company by allowing that is not protecting its legitimate business interests. If company A is not preventing the employee from bringing all the customer list, from bringing the standard operating procedures, anything that is something that benefits your company is a legitimate business interest. What the opposite of that is, Letitia, and what courts don't want a company to do is say, we don't want you to go work across the street because we want you to be handcuffed. We're annoyed that that you weren't a great employee and that you quit. Or, we just really don't like you. You caused problems here, so good riddance. You can't work for the next year. That doesn't cut it. Every non-compete agreement has to be somehow tied to a legitimate business interest. Then, once you get the legitimate business interest, to your point, it's got to be narrowly tailored. It's got to have the right scope. It's got to have, geographic limitations, time limitations, things of that nature. Another thing that we haven't mentioned yet that I'd like to talk about for a minute at some point is it's got to be supported by consideration. But all that is after we make sure that somewhere in the non-compete agreement, it talks about why you're writing it. And the reason is some sort of legitimate business interest that you can articulate on behalf of your specific company.
And so while we're talking about just sort of the activity or conduct to be restricted, are there some positions that an employer would be more interested in restricting in terms of while with the company or even after the company than others? For example, am I trying to restrict the person who makes the French fries in the back or flips burgers, or am I trying to restrict the gamer who comes up with all the coding formula for this specific game?
Yeah, I think that's a good point. Basically, the closer you are to the secret sauce, the more important you are to the company. With the French fry example, interestingly, there's been a trend across the U.S. in probably the last 5-10 years where restrictive covenants for lower wage jobs are really, really disfavored by courts all across the states, and that's because in those kind of companies, to your point, right, that kind of role can be usually replaced pretty easily. And if you have those kind of employees being held by a restrictive covenant, you're handcuffing sometimes, for the sake of doing so.
I think it may have been Illinois that referred to the relatively new legislation in the last 5 years as the Jimmy John's rule, because the sandwich maker Jimmy John's tried to get their relatively lower wage employees to be bound by non-compete, so they couldn't then go to Subway or something after, which is really not the intent of the non-compete. It's not to say, now you're out of luck. You can't go work for the next year, and you're making $11 an hour. It really, as Darius said, it's either the coder or someone with the secret sauce, or in general, even if somehow you don't have the secret sauce, but you're a high enough employee that you could if you wanted to. The CEO or CFO, any of the C-suites, A, they could have the secret sauce. B, they're being paid enough that then they can be restricted. If you're making enough money, it's hard to have an argument that, now I can't earn a livelihood. And that's the argument on the other side. When we're defending the employer, the employee is going to say, but I have to make a livelihood, and you want me to sit out for 6 months or a year? And, someone from Jimmy John's who's making, relatively low wages, that's a compelling argument. If you're a CEO making $2.5 million a year, I guess you could argue, I have such a high lifestyle, I can't be out of work. But is a jury going to be that sympathetic to that? I'm not so sure.
And does the activity have to be novel or unique in some way? Because in that example that you just shared of Jimmy John's, what is novel or unique about making a sandwich? Assuming that, they're using common ingredients that, everybody has in their refrigerator somewhere.
I'm not sure if it's novel or unique, which I think if something is novel or unique, that is great if you can say that. But I think if you can just argue that it's something, well, maybe this is just semantics, it's a synonym for unique, but particular to a company. Jimmy John's makes its sandwich a certain way. And I can kind of see their argument. They don't want you to go to Subway and make the sandwich the same way it was made at Jimmy John's, because that's what Jimmy John's is known for, it's a losing argument. But again, novel and unique is like kind of the pinnacle. But at the end of the day, if there's something that's particular to your company that actually would, again, going back to legitimate business interest, would kind of hurt you to get out in the public, then you have more likely to enforce a non-compete. Yeah, I'm not sure what the sandwich maker at Jimmy John's could do at another company that would hurt Jimmy John's in the public. And the Illinois legislature, I think, agreed with that.
But the guy, to continue the secret sauce analogy, the guy who has the recipe for the hot peppers at Jimmy John's, that guy actually is definitely going to have a unique and like novel knowledge to Jimmy John's that you wouldn't want to get out.
Right. The classic example is always the formula for Coke.
Right.
That's the classic example of a trade secret that you have a legitimate interest to protect.
Or back to my French fry example. I don't want to belabor the French fries, but I love French fries. I mean, there are some restaurants that have a particular taste to their French fries. And so I guess one could argue that they have a certain secret French fry recipe. And I can name one chain unique to the West Coast, and California in particular, that has a very distinct type of French fry. And then there's another, more national, even global restaurant chain that has a French fry that tastes a certain way as well. And people can close their eyes and eat that French fry and know that it came from that chain. I mean, could you say that the person who has access to those recipes might want to be covered by a non-compete?
Probably not in most, especially as Darius mentioned, a lot of states now have a cutoff of you can't enforce a non-compete if you make, let's say, under $100,000 a year, or I think Illinois is under like 75 or 80,000. What you're talking about, though, would be a great opportunity to use a more limited type of restrictive covenant. Let's say a confidentiality agreement or a non-disclosure agreement that says you can leave and go work for a competitor, but you cannot divulge how we make our French fries. If we go to that restaurant and we taste the same taste that we taste at our store, you will be sued. So that's where you want to make a more limited, maybe a non-solicit, that you can't take any of our other employees who make our fries. You can only go take yourself, and more power to you. Go work for them. You can't. You can't prevent them from working if they're a relatively low wage employee. That does bring up something else, Letitia. I think we're maybe going to talk about it later, but I think it lends itself to talk about it now if you want to for a couple of minutes. And I was actually working on a case with a client a few months ago on something that's I think a really interesting nuance of all this, which is called the inevitable disclosure doctrine. Mm-hmm. Now, as I said, most states would say you can't bind this relatively low-level employee from not competing because he only makes, let's say, $45,000 a year, and a lot of states have a law now. But I might argue, okay, fine, so he's not bound by a non-compete, but we're actually going to sue to prevent him from working somewhere else because he was so integral to our French fry making process, and he can't remove that information from his head. It's already in his head, and by himself, without any other help, he could completely destroy our unique trade secret. So we are scared he is going to inevitably disclose our process with our competitor. And it's very hard to enforce this doctrine. It's called the inevitable disclosure doctrine. But if you can prove that he has all the information and you can't unring the bell, and by going to the competitor, which you already did because he didn't have a non-compete, you use this inevitable disclosure doctrine to come in and get a preliminary injunction or temporary restraining order or whatever it is to stop him from working, because otherwise your trade secrets will be inevitably disclosed. It's a really interesting nuance of the law.
It really is, and it just brings to mind so many potential questions in terms of if you hire someone or bring someone on, say you're in the fashion industry, and I want you guys to share with us in a minute what industries are or professions would we most likely encounter non-competes. But before we do that, based on what you just said, Jordan, I think about if you are a fashion house, for example, and you hire a specific designer to design your, spring and summer line, or for however long they are going to be with the fashion house. And they're bringing their uniqueness and how they cut a shirt or how they design a handbag or just their flavor and style. And then they say, well, no, I'm going to leave fashion house A and now I'm going to go to fashion house B. Would fashion house A be concerned that, hey, this person's style, their flavor is so unique that if they leave us and go to fashion house B, they will inevitably compete with us because they're taking everything that we built our fashion house on based on their style?
Yeah, that's a great question. The slight difference from the typical example is it's the employee is the one who's so unique, whereas in the French fry example, the employee wasn't necessarily unique. The French fry making process was unique and the employee knew about it. So he was taking the company A's secret and taking it to company B. Here, it's in your example, the fashion designer is taking himself.
Or herself. Yes.
That can't really be protected. But to your point, if even though it was his own individual style, if fashion house A trademarked all that stuff, or you think of it really depends. When you see some of those clothes, do you think of fashion house A or do you think of the designer? If you think of fashion house A and then he's going to go and do something similar to fashion house B, maybe you could use the inevitable disclosure doctrine for a certain amount of time. But his argument might be, I'm unique, I can do other unique things, and this is me. You can't separate my style from me. Where again, with the French fry example, you could separate the French fry from the person. So that might be a distinction, but that's a really, really good question. That would depend, as lawyers love to say, would depend really on the specific, facts of the case.
Darius, what are your thoughts?
Well, yeah, I mean, the fashion one's an interesting example, I think, because typically when you're thinking about restrictive covenants, and I think we're talking about trade secrets a bit too, the idea of a trade secret is that it is in fact secret, right? Like it isn't known. It gets some value from being secret, and that there's measures in place to protect it, right? That's kind of how you describe a trade secret. With this fashion example, like it's pretty like interesting because there's nothing secret about it, right? That is just someone's creativity moving from one employer to the next. So I mean, I think it'd be a really tricky argument. Fashion house A hurts, right? And I think that's why employers have employee agreements that are going to define how an employee can leave, when an employee can leave, because they are so intertwined with this employee's creativity. But to the extent I think it'd be a very tricky argument for fashion house A when it's and the thing is to your example, the employee goes to fashion house B is entirely creative. If they're continuing their creativity, there's probably not going to be a ton of connection to fashion house A beyond the fact that they worked there before.
And back to Darius made a good point, which made me think, Letitia, unlike again the French fry example where we kind of needed to rely on the inevitable disclosure doctrine because non-compete you wouldn't be able to have a non-compete in that scenario. In your scenario, that's the exact reason you want a non-compete for this designer. You don't want him to go across the street to a different design, to a different company. So at least for a year or two, let's say he has to sit on the sidelines. And as you know more than us, Letitia, a year or two is an eternity in the fashion world, right?
Well, yeah.
And then if he wants to go back to making the same designs from 2 years ago, maybe more power to him once the 2 years are up. But you can't have a non-compete forever. But in that case, you might be able to get it for a year or two. So yeah, I think we kind of went full circle, and your example goes right back to why a non-compete would be important. And then that goes also to your question of maybe the fashion industry, and I hadn't thought of that, might be a good industry for non-competes to be useful. Although I've represent retail stores, I've never, represented fashion designers or anything of that nature. And in a typical retail store where we're mostly dealing with, sales associates just on the floor, I don't think a non-compete is typically warranted. That's very different from traveling salespeople that we can talk about in a minute. But for people behind the scenes designing the clothes, again, I hadn't really thought about that, but I think that would certainly be a absolutely kind of essential position to provide non-competes for as the company.
And a lot of times I think like how employers handle that is pretty interesting, because obviously if you're an employee signing up, you're signing a non-compete, you're going to be concerned about really adverse terms that make it difficult for you to leave. So I think one way that employers I've seen handle it is like, there's I think it's kind of more of an English phrase, but like gardening leave or cool down periods. The idea being like, look, you decide to leave, you can, and maybe you'll be paid for this period of time, but you can't work in the industry for, 1 year, 2 years. And those kind of terms where you're being paid, but you're not working still, are the kind of terms that make it more easy to make your non-compete enforceable in a court of law, because it's not, you're not restraining someone's ability to make a living. You're just restraining like where they're going to do it. And usually those kind of terms can be defined by, very limited role specific contracts. I mean, you can't do X, Y, or Z for 1 year, 2 year. Maybe you do something on the side. Maybe you're on gardening leave or the cool down period. That's a way an employer can protect their interest if they're concerned about going from fashion house A to fashion house B.
And so I think that's a natural segue into the question of consideration, because a thought I have is if we're talking about the fashion designer scenario and fashion house, of course, the employee is going to say, well, there has to be enough money on the table for me to agree to not compete with you for a certain amount of time, because that impacts my livelihood. Jordan, can you talk to us about consideration?
Sure. And there's a few different areas where consideration comes up. First is, and I think Darius may have mentioned it earlier, when you sign the non-compete. The ideal scenario is you get an employee, and immediately upon the start of the employment, you have the employee sign the non-compete. And that's part of the consideration package. Let's say this employee is making, $150,000 a year. Part of that package is he's signing the non-compete. Otherwise, you could argue if you had to in a deposition or something. Otherwise, we would have given him an offer for 120. Typically you don't have to break it down that way, but that's kind of the way you think about it. The next part is you just hire him. You, for whatever reason, you don't think about it. And again, I'm talking about on behalf of the company, because that's where we do most of our work. You don't think about it, and then 2 years later, you say, "Oh shoot, we didn't realize we wanted to sign a non-compete. Either we're worried he's going to leave, or we just forgot about it, or things of that nature." So then you have him sign a non-compete. And some states might say, you know what, just having him sign the non-compete and continuing his employment, that's sufficient consideration. So you want to talk to a lawyer to know if you're in a state where just continuing employment is sufficient consideration. But a lot of other states say, you know what, that's not. You need something else. And you kind of don't want to be, silly about it. You don't want to say, hey, here's $1. Technically, the law says $1 is consideration. You'd want to give this person, a bonus of some significance as consideration. You also could change the title. If someone goes from a VP to a director or something like that, that's probably consideration. But again, that should come with a raise. Don't just change someone's title and not give them a raise, because that would be tough to argue in court that you gave them consideration. They got consideration for the non-compete. So that's the consideration part when they're signing the non-compete to be valid. But to answer also the second part of your question, Letitia, or what I'm going to read into the second part of your question is at the end, when you're trying to enforce the non-compete or you're ending the employment relationship, and Darius kind of mentioned this too. It depends if the individual is leaving on their own or you're firing them. And that gets into a whole other topic about whether you can enforce on termination. And we'll table that for a minute. But if you provide some sort of severance, that's ideal. And especially if you can tie the amount of severance to the length of the non-compete. If it's someone who's a high-level employee and you say, we're going to enforce a 1-year non-compete, we're also going to put you on quote unquote garden leave for a year. And that means they're being paid for the next year. It would be extremely difficult for that employee to then go to court and say, it's not fair. They're restricting my ability to earn a living. All the typical equities argument that an employee would make if you're still paying them. So if at all possible, I recommend garden leave for the exact same amount of time as the non-compete.
Well, while we're talking about non-competes and consideration and fashion houses and French fries, why don't we identify some other industries and professions where non-competes are more common in your experience?
You want to start, Darius?
Yeah, it's one of the main ones is sales employees are under non-competes a lot, and that's because when you think about what sales employees have is they work really, really hard and they build relationships with the individuals that they're selling, services to, or services or a product to. So those employees, they're vital. And if they leave, that is a massive stream that the stream of income that the company will leave. And it's very, very difficult to replace them because, like I said, it's based on these relationships usually. So sales employees are often under these. And it's one of the more, you see those pretty frequently in litigation. Because it is they're vital to the employers. The employers have to protect them, and it's interesting again because when you think about them, it's not often there is sort of a secret sauce all the time, right? Sometimes you might argue that their pricing strategies, their selling strategy is going to be part of what's protected under a trade secret. But realistically, what the sales employees have is in their heads. And with the exception of as we discussed earlier on the inevitable disclosure doctrine, usually what's in your head you can take with you. And in this case, a sales employee who says, I've got these great relationships, I want to go to company B, and company B says, yeah, you might get paid a little bit better here. The terms might be a little bit better. That's a massive harm to company A. So those employees are the kind of employees that I think companies put a lot of effort into getting non-compete agreements signed with.
And to add on to that, we've represented, food services companies, and some of them, the jurisdictions are pretty small. Let's say there's this food service company in Phoenix, Arizona. There's 4 or 5 food services companies that are selling to all the same restaurants. And there's so much litigation in this region because the salesmen try to go from one company to the other. But to Darius' point, not only do they have all the information, they're all calling on the same customers. So one day someone could be calling on that customer that they've spent 5 years building up a relationship with on behalf of company A. And then if you don't have a non-compete, the next day they're calling you and say, hey, you're about to send me, 20 pounds of this food, or I was going to provide you 20 pounds of this type of this item for your restaurant. Well, now I can provide it for a few dollars cheaper. It's just I'm working for a different company now. And the guy will say, sure, that sounds great. And, company A just got undermined. So the big thing with salespeople is, that they're calling on the exact same customer. So you don't want someone, that's why at least you want them to sit out for 6 months or a year. Then they have to try to build up the relationship with the customer again, instead of literally just going to the customer the next day. And then other than sales, certainly pharmaceutical companies, think of companies like Pfizer, Novartis, companies that have a lot of proprietary information. I think Darius had mentioned earlier, with trade secrets, one thing you need to be able to show to a court, to demonstrate to a court, is that it's actually secret. So any company where some of their secrets are important, and again, if you think of drug companies, pharmaceutical companies, they don't want their competitor to know what's exactly going into their drugs. So I think that's a big one. There's a lot of other medical fields. Some states actually don't let you have non-competes with doctors. Plenty others do, and I actually see non-competes a lot in the medical field. And you think, oh, that seems kind of a little not ideal from a public policy standpoint. But a lot of hospitals want to protect their proprietary way of doing things. So you actually do see it a lot in the medical field. You don't see it in the legal field. Edge. Say that again.
Their competitive edge. If one facility has the top heart surgeon or brain surgeon in the world, of course we don't want this person to leave us and go down the block and work for the other healthcare institution.
Despite the fact that the public policy is we want to make sure that heart surgeon's working, so someone who needs surgery can get surgery. So that's where it gets interesting between the competitive edge from the business, kind of contrasting with what some might argue, an employee would argue, is the public policy aspect. That employee would say they need me working. So that would be an interesting argument. I always find it interesting that lawyers who write the laws think so highly of themselves sometimes that they can say, sure, the best heart surgeon in the world, he can be bound by non-compete, but us lawyers, we're too valuable. We can't be bound by non-competes. And we want our clients to be able to choose whoever they want, and we can't. If we leave a firm, too bad for the firm, but the client has the ultimate right to choose who's representing them. So it's kind of nice that us lawyers don't have to worry about non-competes.
This is true.
So I have two good ones here to ask you about, and I know we're coming on time, but these are good ones. One is the tech industry, and you see a lot of competition happening right now, trying to claim the AI space, right? Who's going to really lead that space? And I think there's one tech giant that was offering a several $100 million signing bonus to sign on with them, to help them really dominate in this space of AI. I mean,
Letitia, do you know if they need a lawyer? I mean, I love Conn Maciel, but $100 million signing bonus, I can provide them good employment law advice.
Wouldn't that be an example of, okay, you just paid this person a $300 million bonus to sign on with you? Of course, you don't want them to leave you, especially when, there's several tech companies that are racing in this AI race, when we know that everybody is thirsty for the person who can help them really dominate the space. We don't want that person to leave and then go work for someone else. And in this space, would it really be what is considered the geography? Like, what's the in terms of the space?
Well, Darius, you go.
No, so I would say that. I mean, I'm sure geography isn't a like geography, like I was saying before, isn't always a factor. But I would bet for something like AI, I mean, like, because it is so computer based, I don't think geography is going to be a real factor. I think you were going to be very unlikely saying, like, and particularly if you're getting athlete signing bonuses for an employment contract, to say this can't be a worldwide ban. I mean, I think as well.
Non-competes have been around for a long time. In the 50s or 60s or 70s. Geography may have been the most important factor. I'm opening up some sort of business. I don't want you to go across the street and hang up a shingle. The probably geographic limitation didn't need to be more than 25 miles. If you worked 25 miles away, you were fine. Now, as Darius said, especially in the tech industry, but in most industries, you could easily argue that there's geographic limitation just isn't relevant. As with the fashion, the duration is relevant. And AI, if someone's out for a year, that might be plenty of time because things happen so fast. But for so many years we said you got to have geographic limitation, duration, and scope. You got to almost forget about the geographic limitation. Some of these, I don't see it. I don't think a court would find it unlawful just because it doesn't. And like you said, how could you have a geographic? It just doesn't make sense.
It is interesting though, like those geographical limitations. Like I remember looking at them once upon a time. It would be like 25 miles, like as a crow flies, and that's how you would determine whether it was a reasonable limitation. And that, for some things, just seems so archaic now.
Absolutely. Another example I have, and this is very fresh, but we're seeing it more and more now. You have personalities, whether it's radio personalities or TV personalities, who leave the TV space and then they set up a shingle, I guess, in the virtual space. And so suddenly they have a show on YouTube when they used to have a show on a major network. How would non-competes potentially apply to that?
I'll let you start, Darius.
Yeah, it's a good question. I mean, so it's again, like it's kind of a bit like the fashion designer example. Like it's really going to depend on what that contract says. On the one hand, right, they're taking their own services somewhere else. It's not like there's likely a secret sauce or some kind of like real specific interest that they are going to be able to say, they're moving from A to B and is really going to harm A by virtue of this special interest that A has. But, I think usually that's going to be like an employment agreement where, company A is going to want to protect their interests moving forward in terms of a customer base. And that's where you'll have a restrictive covenant they'll want to, sensibly defined, meaning making that the terms are reasonable to both parties. I don't think it's going to be easy to say that there is some kind of, obvious legitimate interest in terms of trade secrets, but mostly client goodwill or, customer goodwill is what they're going to want to protect.
And I think, it might just depend on, how good your lawyer is to draft a good non-compete. Years ago, as I think I mentioned earlier, in a non-compete, it's if you can be, the more specific you can be, the better. So years ago, let's say there was an anchor on CBS. Maybe they had a non-compete that instead of just saying you can't go compete, to a competitor, they actually defined you can't go to ABC, Fox, NBC, or anywhere on cable. Let's say they defined it that way. At some point, someone probably got the short end of the stick and they kept that non-compete language. And then all of a sudden someone's like, haha, now I'm on YouTube. And then the lawyers had to go scramble, be like, we got to change our non-compete. And now it says you can't go to NBC, ABC, CBS, cable, or any streaming service or any virtual, and you just have to keep on basically defining it with the times. But if you didn't, and you just said you can't go to a competitive company, let's say, or you can't work for some type of competitor, that would be where there'd be litigation right now. And it would be kind of, for a lawyer, quote unquote, fun litigation. Is YouTube a competitor of NBC or something like that? And again, that's why you want it. The more specific you can be, the less likely there is for litigation over a specific word. But to your point, now I would argue that you certainly could say how a streaming service is a competitor to a TV station. 5-10 years ago, maybe it would come out the other way.
Well, especially now where research has shown that most people are getting their news from social media, and most people are watching YouTube versus cable. And so if you have someone, say they have 2 million followers or more, and suddenly they leave your network and they go start a show on YouTube, I think an employer would say, well, they're taking those 2 million followers that really found them on our network and were viewers of our network. And now those 2 million are going to leave us and watch them on YouTube.
And exactly, Letitia, and to that point, and circling it kind of back to the beginning, if you were in court and arguing about whether the non-compete should or should not be enforced, my main argument would be, we just lost 2 million viewers, or our non-compete should be enforced because clearly there was a legitimate business interest. The interest wasn't to stop this one person from broadcasting. The legitimate interest was for us to not lose 2 million viewers. So that kind of ties it all back to what the whole point of the non-compete is, to protect whatever it is you're trying to protect, your secret sauce, your viewers, your designs, whatever your business is. You're drafting the non-competes to protect yourself.
And this is why you need to be calling Jordan and Darius to draft your non-competes, especially in this changing business environment.
Exactly.
Yeah, they're not stopping you from speaking. I think the argument is that I'm stopping you from having a show that you can't leave my network and then create another show that's basically the same thing you were doing on my network.
Sure.
Stopping you from broadcasting. Yeah.
Right. Maybe if you were, say, doing sports broadcasting, and now you want to discuss music videos, maybe that's different if music videos are still a thing. But if you're just going to go from, the sports network to now being solely on YouTube, and you're basically running a sports channel, and, you're having all your connections too to athletes and to other reporters coming on your show like they would come on the network. I don't know. I think that's problematic.
Yeah, you're taking away customers. It's just like the sales example we talked about earlier. You're taking customers from where you used to be. Then they invested a lot of time, money, and effort to you, and now you're saying thank you, and now let me take those customers away from you.
Well, one interesting part of this, that you have a non-compete, which is about restriction on trade. The second part of this that really touches on kind of a business's real central tenet is their customers and their other employees, and these are non-solicitation agreements. Non-solicitation agreements are another type of restrictive covenant which an employee will sign, and the idea being that once they leave, it'll kind of define the terms around whether or if they can solicit clients or their colleagues at their first company. And those are pretty interesting because that's, again, another place where a lot of litigation comes up, because usually what happens is when it comes to, we'll start off with customers, the idea is that once you leave and go somewhere else, if you are, lawfully at employer number 2 and you have these customer relationships, typically, not always, and it's going to depend on a case-by-case basis, what a non-solicitation agreement will say is that, you can't reach out to these customers, but it's really difficult to restrain, the actions of a customer. So if a customer follows them on their own accord and goes to company 2, those kind of actions are kind of like where litigation can arise, because typically, the customer's got free rein for who they want to follow and who they want to, purchase services from.
That, again, thinking of current times, and maybe the law needs to evolve in this space. But if, suppose employee doesn't necessarily solicit customers or current employees, but gets on Twitter or gets on TikTok or IG and says, or even LinkedIn and says, well, hey, by the way, I'm no longer over there. I'm over here at employer B, or I have my own operation going, just letting you know about all the fabulous things that I'm doing here for all my clients, including bulleted list. I mean, that's not, it is a solicitation, or maybe it's not. What are your thoughts?
That's exactly the type of stuff we're seeing. And it's, I think most people would say that kind of is a solicitation. If I was counseling an employee, I would say keep your head down as much as you can, but the employee's now at a new company and they want to make a name for themselves and they want to advertise. They would say, I'm not asking anyone else to join me. I'm just, working at the new company. So it really is tough from both, again, to be clear, the non-solicit is two things: not soliciting the other of your employees from company A, and not soliciting the clients or the customers from company A. But to your point, Letitia, they're called non-solicit agreements. I honestly don't know if you can have something called a non-taking agreement, where you agree not to accept any employees from company A or not to accept any clients. I just kind of came up with that on my own. I don't really know.
I've seen that. Don't know if it's lawful.
Right.
I've seen.
Yeah. So that would actually take a little bit of the uncertainty away, because Darius and I have worked on cases where this exact middle ground said, someone says, well, I just let people know that I'm not with the company anymore. I didn't actually ask them to come with me. And, then it all is so much litigation comes on it. He said, she said, well, you didn't tell them not to go with you. And, you left the door open. So, yeah, that can be a whole kind of separate topic that we could get into.
And the analysis in those kind of cases becomes like a very interesting like line drawing exercise, because, in a customer, like our LinkedIn example, like sometimes what you're looking at, like, there's a LinkedIn post, but did you send them specific emails? Did you send them specific emails, directing them to this post? Were you actually trying to solicit them? How were you doing so? And like what your specific communications were and who to, and how direct they were or how vague they were. That's really what it's going to come down to determine whether or not you're soliciting employees, with the obvious caveat of depending on what your agreement says.
Well, it sounds like we are trying to apply a necessary but old law and framework to a new and different business landscape for many, especially in the virtual space. So it sounds like folks should be reaching out to the two of you to help them, understand what their rights are and opportunities are in this space, as things are changing, and you want to make sure that you have all bases covered. So that said, two last points, then we got to go. But the first one is, Jordan, tell us the current state of the FTC rule. And then I want both of you to tell me what it means or could mean if the employer is the one who terminates the relationship.
FTC rule is no more. Some of you might know that I think it was in April of 2024, the FTC instituted a rule saying non-competes throughout the country were no longer lawful, and even retroactively. That never came into effect. It was supposed to come into effect in September of 2024. I had lots of clients calling in July. What are we going to do? And I said, just wait. Everyone reading the tea leaves, we all kind of thought a court was going to strike it down. The court struck it down, kind of being an overreach for the FTC. And the FTC recently decided they're not appealing anymore. So hopefully no one's under the impression that non-competes are no longer lawful, because that actually never happened, and now it is certainly not happening, other than in the 4 states, in there are 4 specific states, if I can remember them. I believe it's California, North Dakota, Oklahoma, and Minnesota. Non-competes are basically not legal there in any way, shape, or form, at least connected to employment. They may be legal connected to a sale of a business. But yeah, let's forget about the FTC rule at this point.
Thank you, Jordan. Darius, why don't you talk to us about what happens if the employer is the one who ends the employment relationship? Should the non-compete still stand?
So, yeah, it'll depend, right? So usually what happens when you have an employment agreement with a restrictive covenant within it, oftentimes how they're drafted, and again, to go back to the central thesis of today, really important to have a good lawyer draft these and review them before you sign them. They'll have specific requirements depending on who terminates and how much notice is given. So oftentimes, if an employer terminates, there will be specific clauses indicating how the restrictive covenant is applicable. And the same for the employee. If the employee terminates and for what reasons will depend on how the restrictive covenant will apply moving forward. Typically, when you draft it, you want your restrictive covenant to be, universal. It's going to happen no matter what happens, no matter, why you leave. But there are incidents like these are contracts, right? So if an employer breaches the contract, then that can change how the restrictive covenant applies moving forward.
And I'll just add in a little bit, Letitia. For the most part, and from a policy perspective, even though I'm on the behalf of employer, like I say, you represent both sides. I kind of disagree with this, but for the most part, if you terminate an employee, as an employer, you can still enforce a non-compete against that employee. I think that's wrong. If you terminate them for cause, I think you should be able to enforce it, because then they're almost like trying to get fired. It's just like they're quitting. If they steal something from you, you want to be able to enforce it. But what? And I've argued this before, and there may be a few states, I think New York, where I argued it, actually doesn't fully allow non-competes to be enforced against terminations without cause. And, the rationale from the court is you shouldn't be able to use a non-compete both as a shield and as a sword. If you think about it, it kind of really is unfortunate for the employee for a company to say, we don't want you working here. We're firing you. We don't think you're good enough to work in our company. By the way, don't breach a non-compete. We don't want you working for a competitor either. Seems like, what do you mean? You didn't think I was good enough? But most states actually allow you to enforce a non-compete. I kind of think if you quit, it's one thing. I do think it really is a balance of equities issue if you get fired for no reason and then can't work. But most states allow a company to do that.
Yeah, I mean, it's so interesting. Like if you apply that to the geographic restriction, which I know, like kind of we mentioned, doesn't apply as much. But if you're living somewhere, you have a geographic restriction, you're fired, and then suddenly you can't compete. I mean, you're in such a tough position because by definition, it means you're going to have to either, find somewhere outside of the geographic restriction, which has massive implications for someone's life, right? And that's hoping that there is a position available.
Yeah.
Thank you. And with that, I think we have fully explored this topic. I want to thank our very special guests, Jordan Schwartz and Darius Rahani Shukla, who are both attorneys in our Washington, D.C. office of Conn Maciel Carey, a national labor and employment law firm representing employers across the country, across all industries and workplace matters. So until next time, stay ready so you don't have to get ready. Thank you.
Thanks. That was so fun.